Recently, the government of Indonesia, actually the Ministry of Manpower in Indonesia, issued the new regulation to implement the reformed employment injury insurance regulation. And the reference is Ministry of Manpower Regulations number 1, 2025. And this regulates the implementation procedures of new employment insurance, employment injury insurance operations, the revised one. And this morning I'm attending a workshop organized by BPJS Health Supervisory Board meeting, and I'm asked to comment as a discussant on the role of implementing regulations for EII in the new regime. And in short, as long as I understand, the major reform made this time was to clearly define who is liable for paying medical care costs for the first 30 days until the industrial accidents were approved. So previously there was an issue that hospitals possibly denied accepting injured workers because hospitals, medical care institutions were not sure whether BPJS Health or BPJS Employment would cover the medical costs. So they were not sure. So some hospitals were reportedly denied to provide a treatment when the affected workers came to the medical facilities. Another reported case was that the health insurance, BPJS Employment, detected quite some cases. Industrial accidents cases were reported to JKN, BPJS Health Insurance, instead of JKK, Employment Injury Insurance under the BPJS Ketenakerjaan Employment. So there was a suspicion that suspected cases for industrial accidents were reported and used JKN health insurance, and then the government suspected this was part of the reasons that the health insurance fund was depleting faster than they expected. So this regulation was issued. Actually, the government regulation back in 2023 regulated this responsibility divisions between employment, BPJS Employment and the BPJS Health. And the Ministry of Manpower regulation was just issued to implement this new modality. So today I was asked again to present the kind of general overviews and the common issues across the world for the general procedures of EII. We haven't completed any relevant studies focusing on Indonesia. So we are actually conducting several studies on EII this year, including actuarial evaluation to check the financial balance on EII, as well as we are assessing the compliance of the current EII in Indonesia against the international social security minimum standards. there are several parameters that are not reaching the level of international social security standards. So we will review from legal perspectives, and then also we are going to calculate the potential costs if Indonesia complies with the social security minimum standards. So these two major research activities would be our real contribution in this year. But as this request came actually last week, I'm more than happy to present what I could say at this point this morning. So let me just quickly go through, possibly for the next 10 minutes, I'm going to talk about the general procedures and common issues for claiming employment injury benefits. I wouldn't name any countries specific, but I would like to illustrate the common issues and the general procedures for claiming the benefits. So Indonesian stakeholders who are more knowledgeable about the Indonesian context could compare what are the missing points in their current system. The employers have a general obligation for OSH, occupational safety and health. So they are obliged again to report in any industrial accidents cases to the labor authorities immediately after they got the reports from their employees. And then they will have to explain the procedures, the claim process of employment injury insurance to their affected employees, so that employees will be kind of knowledgeable and they would know what to do next. If employers do not fulfill these obligations, usually the criminal law imposes fines or imprisonment on employers. So if employers hide industry accidents cases, they are usually punished by the OSH law. But what is the case in Indonesia? Who claims employment injury benefits? Usually, in principle, affected workers themselves have to claim the benefits. But in the case of survivors' benefits, heirs usually claim because workers cannot claim. Exceptionally, companies can help in some countries to process the claim when affected workers are not in a good condition to process the claim administratively. If employers do not agree on the recognition of industrial accidents, the workers can still claim the benefits, but they can actually directly report to the labor authorities and to recognize industrial accidents, and the social security institutions can start process to provide benefits. Even if employers didn't register their employees, for example, by breaching the laws and the regulations against the mandatory responsibilities for them to register, workers can still benefit in that case in many countries because it's not the worker's fault. There is a certain mechanism for workers to actually use a designated hospital for occupational injuries or workers' compensation. If workers use the designated medical institutions for occupational accidents, they wouldn't have to pay medical expenses usually. So workers tend to go to these hospitals when they suspect injuries happened during their working hours, And so workers do not have really a big incentive to go to the other hospitals. So this is a mechanism to encourage workers to think about this is occupational disease, injuries, or normal injuries or diseases. Because in Indonesia, workers are not very aware of which hospital they should go in the case of industrial accidents, or they are sometimes really not aware of the difference between industrial accidents and normal accidents outside the workplace. So this is a mechanism in place in some countries that workers need to think this is really occupational injuries or not. And then they choose to go to the medical facilities, the designated medical facilities, if they think so. So this is to show their opinions, right? So if workers go to the other hospitals, not registered as such a designated hospital for industrial accidents, they would usually have to pay the full amount. Possibly, of course, they may have other insurance. So if they go to the other hospitals, they may have to pay the full medical cost. So if they really think this is the case of industrial accidents, the workers usually go to designated hospital. The obligation of medical institutions and doctors, if the doctors okay, first of all, doctors are not really permitted to refuse the patients. In some cases reported in Indonesia, doctors and hospitals refused because they were not sure if this is an industrial accident case or normal injuries, and they were not sure whether BPJS employment or health pay the medical cost. But in principle, by laws and regulation, usually doctors are not permitted to refuse any patients, so they have to treat them immediately with or without any reasons, except only without good reasons, right? The medical care institutions and doctors are again obliged to report to the labor authorities for any suspicious industrial accident case. If they suspect, they have to report to the labor authority. In some case, then doctors and medical institutions may say, we paid a lot of attention, but we didn't notice, and so we didn't report. We don't know if it's true a statement or a false statement. But again, having said that, medical institutions and doctors still owe a duty of care. So the lack of awareness on their side is not the issues. That is also their responsibility, even though they were not aware of. So that's usually the case in many countries. What happens if workers used health insurance for industrial accidents on purpose? Usually this leads to the serious consequence. Workers are imposed on fine or imprisonment for criminal fraud if they do it on purpose. Similarly, if hospitals and doctors also know about to certify this industrial accidents case, if they know this is actually the industrial accident, but they certify to use health insurance, they would be also, imposed on fine or imprisonment together with the patient. So there should be a checking mechanism between workers in medical institutions and doctors to identify and report industrial accidents to employment injury insurance. What happens if workers use health insurance by mistake? Usually, if a worker uses health insurance by mistake, and then the health institutions will send an invoice to return the full money to full cost to the health insurance fund. So what workers need to do is to first report the fact that they used the health insurance, but they got to know later that was an industry accident. They would have to report to the health insurance authority. And then the health insurance authority will send the invoice to this worker, and the workers would have to pay back the full amount of medical care costs. And then the workers would have to report to the Employment Injury Insurance Authority to receive the medical care costs. So there is a cash flow of burdens on workers. So workers must be very careful to when they choose to go which hospital, right? When it comes to industrial accidents. So if it is suspicious cases, they would have to go to designated hospital for industrial accidents, and they would have to use the employment injury insurance card to receive a medical care services. So this is the worker's responsibility, is really to take the first action. And if workers use a designated hospital for industrial accidents, and then they use the health insurance card by mistake, the workers may not have to return the full amount at the end, but within the medical institution, they may be able to switch from health insurance to employment injury insurance. This operation is usually possible because the hospital has already the network and operational relations with both institutions for health insurance and employment injury insurance. Mm. Yeah. So what happens if what happens if a worker has used the designated hospital for industrial accidents, but later on it was decided that the case was not work injury. Workers usually then must return the full amount of medical costs to the Employment Injury Insurance Fund, and then workers can still use the medical health insurance card to cover the medical costs if they are covered by health insurance. Then workers can still appeal if they are not satisfied with the decision of non-work injury, non-work related injuries. So there should be such a mechanism in place. So there is a potential issues to be discussed in Indonesian context. Do laws and regulations clearly stipulate obligations and penalties for workers, employers, medical institutions, and doctors to enforce the general operating procedures like this? and what happens if they breach the laws and the regulations on, you know, in these cases. And do medical institutions and the doctors have knowledge and the capacity to identify and report industrial accidents to the labor authorities correctly, accurately? Because these are the responsibilities for medical institutions and doctors. If they miss the cases, what would be the consequence? Would be penalized, or is there any mechanism to enforce this? So maybe these are some of the key issues for me to provide inputs to the Indonesian context. In Indonesia, I mean, last but not least, in Indonesia, health insurance provides the free medical services, and if they have a health insurance cards, that's probably not the issue to cover the costs of industrial accidents cases. So many people tend to use, health insurance cards, of course. But I think it is important for the government to direct industrial accidents cases to the employment injury insurance fund. Otherwise, the insurance mechanism, insurance principles would not be fulfilled if normal injuries are claimed to JKK, employment injury insurance, and industrial accidents cases are claimed to health insurance. It would undermine the insurance principle. So it is important to discuss in detail the general operating procedures and enforcement mechanism. Thank you very much for listening, and I hope this is somehow useful for stakeholders.